Got it.
Got it?
Okay.
You have to have the mics on.
Yeah. But, well, you do as far as to record it, but.
Well, what I'm saying, you want it to make, because this is what I do.
Oh, okay.
People can hear me 3 miles away.
Okay.
Democratic legislature.
We might want to, definitely, we might want to.
Good on myself.
You might just want to talk into it because these are very sensitive. So meaning that if when you swing it over there, it's probably not going to pick you up.
Well, I know that, it doesn't need to.
Oh,
That's what I'm saying.
Okay.
You can hear me.
I hear.
Is there anybody out there?
It is on. It's on for recording.
Yeah, it's mostly on. So whenever you're ready, sir.
Good evening, ladies and gentlemen. Good evening, lady in the audience, our one audience. Hello and a welcome to my fellow new commission members. We've taken a look at the agenda, reviewed the material. Are there any suggestions for revision of the agenda tonight? Hearing none, the agenda is deemed adopted. I invite any comments from the members at this time, starting on my left with Rabbi. Any comments?
At this point? No comment.
Judge Beck? Tina?
No comment.
All right. Any comments from the public? No comments from the public. The next thing on the agenda is to elect the vice chair. I've taken the chair's prerogative and moved that out of turn, and we're going to take up number 5 first to determine the commissioner term limits as required by the ordinance, the rotating terms in 1-year increments. Does the clerk or Ms. Robinson have the
clerk
straws to draw or the numbers to draw? There it is.
It's very high tech here.
Very good.
Okay. So let's take one of those, sir.
I hope it's peppermint.
Then we'll just have each of you announce there's a number inside the card, and we'll just go and ask each one of you then to actually state what the number is on the card, if you would. You got it? Okay.
I got the one that's left.
Rabbi Sherwood?
2. 5.
Professor Gooch? 5. Congratulations. I have 4. Ms. Resno? Congratulations.
Thank you.
Obviously.
Liz Beck? All right. Those terms shall be recorded by the clerk. Next, the election of the vice chair. I think you've probably taken a look at our material. The vice chair sits for the chair in the chair's absence and has the usual duties of a vice chair. It's open for comment, nominations. If anybody has any criteria they'd like to discuss, that would be fine.
Well, my hunch is that since the ordinance says the chair should be a retired judge, I think the appropriate vice chair would also be a retired judge.
Well, that's you make a point. There is also the opposite, that the chair is always selected by the Board of Supervisors and not within the commission itself. So another view would be that the opportunity to have that position might well go to somebody who would not otherwise be qualified to chair under the ordinance. One of the, if I may consider them laypersons, that may not be accurate, but there is that, and I think that should be at least considered by us as potential criteria. Any comment from the political scientist?
No, not at this point. It strikes me that probably someone with a short-termer, so there could be more rotation later on. Might be an idea to have.
That's a good
somebody
idea.
with 1 or 2 years, duration, simply so we could have more rotation as we go. But until we really get into the duties, obligations, and the workload,
Yeah.
all of us are a little gun shy.
True. let's, do I hear, I think we have in mind our respective terms. Do I hear any nominations?
I would nominate Mr. Booth. You have 2 years, right?
Five.
Oh,
Yes,
sorry.
fine. She withdraws her nomination?
No, well, if your suggestion sounds good, how about the rabbi?
Rabbi Sherwood?
Sherwood?
I would are you a 2-year?
I'm 2 year.
Yes, and I would nominate you for vice chair.
And I'll second that.
Okay.
Oh, the chair shouldn't second. Do I hear a
I'll
second?
second.
Thank you. Any other nominations? Nominations are closed. Call for a vote. All those in favor say aye.
Aye.
All right, we have the vice chair. I'm resigning. Congratulations.
Jake with his hiking boots.
I hope that all of our meetings will be in this kind of spirit that we're enjoying what we're doing.
We better enjoy it while we can. The election season will soon be upon us. Are there any, let's see, next we should review the Commission Procedures Manual. There has been a handout of the Brown Act, and we have that, and I think it's something we'll have to go through. This is not, of course, the place to do it, but all of us need to be cognizant of that, and as we become more acquainted, there will be, I'm sure, occasions for us to get together when we are not at a public meeting, and I think knowing that we're subject to the Brown Act is a cautionary note, that when we are, we certainly should not discuss commission business. Yes, Ms. Robinson.
Yes. I would suggest that the commission review the Brown Act as is outlined here, and if you have any questions at your next scheduled meeting, maybe county council could answer any of those, for those of you who have not functioned under a Brown Act, in a Brown Act environment previously.
Yes, that would be fine. You want us to review this now?
Not necessarily. I just mean that you can review it at your leisure,
Yeah,
and,
all right,
and make notes,
That's fine.
since you're just receiving it at
We'll
this
go
point.
on the nightstand with War and Peace.
Right.
Yeah.
On the statement of economic interest, that's the second, if you look in your packet, it says Form 700.
Yes.
That's the form. You are required to complete one of those. The clerk of the board, so if you will complete them and get them back to Roberta within 30 days, that would be very helpful.
Yes, and for those who haven't filled those out before, they are complex and some people might say intrusive, but it's important that those be done. We are a commission that is going to be dealing with these very matters in a different light, and I think the more thorough job we do, the better we will look. The draft policy manual. There are some draft policies in the binder that has been handed out to us some days ago. We will have an opportunity to review it more thoroughly. I would ask as chair that perhaps at our next meeting, county council be present.
And we do have county council
Oh, we
here
have county
tonight.
council here, of course. Thank you. You're familiar with the policy manual and the draft?
Yes, I helped
I
revise
that's what I
them.
thought, yeah. And your name for the record?
Matthew Smith. I'm an
Thank you,
assistant
Mr.
county
Smith.
counsel.
Chair Stone, if you would like, Cheryl Monzon from my staff has worked on putting together the manual, and maybe she could just give you a little background about how we pulled this together. And then county council was responsible for putting together the hearing procedures. So if you would like to spend some time now to sort of get an overview of that.
I think that would be very good.
Okay.
We're here, and we don't have a big agenda,
Okay.
and I think it would be a good opportunity to do that.
Great.
Do you want to start, Ms. Monzon, with the policies?
Well, I just wanted to first let you know that we used the San Francisco and San Diego procedure manuals, and we modified those to reflect the reduced requirements in the Ventura County ordinance. So it's basically the same with the revisions, and also the hearing procedures were added to our our draft policy, which were a separate document. And in the handouts that I have provided you, just so that you will know, the flow charts, the colored documents, are actually after several meetings with elections, so that you would at least be able to see how they process the documents as they receive them, the filing forms.
Our goal in putting the procedure manual together at this point was to give you some method of operating, and certainly a method of you at some point in time need to adopt the procedures manual, and then you can amend it or change it or do whatever it takes for you to operate your business. But we thought it would be best to at least start with something that you could look at and move forward with. So we also are trying to keep staff costs down relative to support of the commission. So the types of procedures we've outlined are with the focus of trying to get to the merit of what the commission is put together for without a whole lot of bureaucracy. We have provided you, Cheryl has provided you with the flow charts, which you can set aside entirely, or if you want some more reading along with War and Peace, you can review, because they are very minute in terms of what's happening. But we had to do that in order to understand at what points in the process with the ordinance there had to be checks and balances, so that in fact we could give your commission information that you need to have. So that was the purpose of that exercise. Okay.
The one thing I would like to maybe have Matt help to discuss, the hearing procedures that he drafted, it allows for a pre-hearing procedure which would, where you would assign one of the commissioners responsibility for reviewing a complaint or an issue that's brought forward and determine whether or not it has probable cause. And then from there, the full Ethics Commission would be brought together to review, to determine.
I noticed that when I went through the material, and I think it's an excellent idea to screen some of the, to keep below the radar screen those kinds of matters and those kinds of issues which should not take up any significant time, public time. I noticed that, and I think it's a good idea.
The only thing I was wondering, though, is that, I mean, essentially it was, if I can use the term I understand, it's a preliminary hearing.
Yeah.
I don't like microphones. And I was wondering whether or not that should be done by individual commissioners as such, or whether it ought to be done by staff with overview from the commission.
As I saw some of the policies and procedures, there were staff initially, as the paperwork comes in from the candidates, much of it is now on the way to being very automated, and the computer will be picking up errors and issues and problems in those kinds of filings. The economic filings and the reporting program of the candidates and the spending program of the candidates. And much of that will be handled administratively as these things come up, because a lot of them will be inadvertent or advertent errors that can be fixed at the very lowest levels as they come in. And it may be that at some point, well, and maybe we should review whether or not a commissioner should review those complaints, because I don't think all complaints ever necessarily even reach that level.
Well, obviously the procedure we're talking about now is whether it is a complaint with any merit whatsoever. Mm-hmm. I mean, that's indeed what we're talking about now. And I have no idea and no experience on this, but that may be the majority, it may be none. I don't know.
It's the sense, I think, of the history of these kinds of committees and commissions, that the vast majority of difficulties that arise in these things are more of a technical nature and rarely become very high profile, but there are, in numbers, I think most of them are
I
very...
have a hunch that, especially with this being a new ordinance, that there'll be a lot of technical glitches and a misplaced number and a misplaced that, and I think the more rapidly we can dismiss those,
Yes.
we don't want to make us or candidates go crazy.
We'll never even see those, I don't
Yeah.
No, well, but that's why I was saying that it seems to me it might be a lot faster to do it if staff did it
Yeah.
than if we individually did it.
And we can have Mr. Smith comment on that. Do you have a comment on the levels at which the commission gets involved?
My comments are, well, I have a couple. First, I think if you want to have staff, that's ultimately your decision. That's one you can make. In making that, you should probably recognize that the staff will be from the CEO's office, not from the county council's office, because of the inherent potential for conflict of interest that would arise, especially if the complaint is against or by a sitting elected official, or the potential conflict of it, someone who ultimately was elected and who we then had formed an attorney-client relationship with. But also the fact that the commission is there to and is appointed and given the authority to make these decisions. So ultimately, I think the ultimate decision will have to be by the commission.
Well,
whether the recommendation is coming from staff or from an individual commissioner. These are drafts, and obviously you can revise them as you see fit. But the initial idea was to have the decisions, made by the commission to remove any potential issues of conflict or whatever from the staff people who, again, if it was a sitting board member, for example, member of the Board of Supervisors, staff might have at least the perception of a conflict of interest there as well. So those are all things that would have to be dealt with.
And there are legal ramifications of those. Those can generate lawsuits. And there's also the political aspect of it, that we are a public commission. We're here to serve the public, and the public wants us to do that. We're sitting as a commission in part because they don't want a hired bureaucracy to make those kinds of decisions. And I think we have to be careful about that and not delegate those kinds of matters to staff. But these are all going to be part of our discussion as we move forward to adopting our policies and procedures.
If what we are talking about is only a matter of making sure that the paperwork is filled out correctly, and if in fact all of the data necessary is in the packet, that just reinforces that I think it ought to be done by staff, who's far more able to do that than us.
Yeah, many of the violations will be technical. They'll be inadvertent.
From what I heard, I think somebody said most of them would be.
Yes.
If I may, the elections group automatically reviews all filings to make sure that they abide by at least the deadlines and that the numbers transfer over to this cover page. So those kinds of omissions or errors will be corrected automatically from staff.
Then what is it we would be doing?
My understanding there would be if staff identified a contributor that may have exceeded the donation limit and was not identified. So it's not a typographical or a transfer error. It's an actual violation of the ordinance, where we will find maybe a donor who's exceeded either the $300 donation level or the $600 donation level, or there are anonymous contributions exceeding the $250 limit. Those kinds of issues where staff would not be allowed to address in the ordinance, those issues would come forward to you.
Yes, because and we also will be receiving citizen complaints, or one candidate making accusations against another candidate for violation of the ordinance.
No.
It is a stunning thing these days, isn't it? Well, there's also, we have the authority to to rule and to assess civil penalties, and to refer matters to the district attorney's office when we feel that there are a criminal investigation.
No question, but those are all things that are going to come to us as a committee as a whole.
Yes.
I'm only talking
No
about
question
this
about
this preliminary
Yeah.
process, and it just seems to me that it's a procedure with nowhere to go. It just seems to me that if it is properly filled out, if the violation is there at least in the paperwork and in the allegation, how would we say no?
Well, I think all we're talking about is a preliminary screening by one member of the commission who would take more time at it than the entire commission, then report to the commission, I suppose, that this particular matter either has merit or does not have merit and should not go forward, and we'll get an explanation from the commissioner and rule, and it will be gone.
I understand that, but if everything is filled out correctly, how would you find that there wasn't any merit to it?
Well, we don't deal with those. We have to wait to see what kind of complaints come in.
I perfectly understand. I hope we're communicating.
I think
all
we
I'm
are.
saying,
We are communicating, although badly. No, I'm just kidding.
Mr. Chairman, as far as the intent when that particular provision was drafted, it was, in the legal context, it was similar, I think, in my mind at least, to a demurrer proceeding, where we're looking at the sufficiency of the allegations in the complaint to see if what they've said, if true, would constitute a violation. And if it does not, then you would just refer it back and say we're not going to handle this. But if the allegations were sufficient to at least allege a violation of the ordinance, then it would go before the full commission for a hearing. That at least was my thinking.
Well, I don't mean to beat this thing to death, but if there's a violation of the $300 or the $600 violation, and then in the paperwork it says that there was a contribution of less than either of those amounts and whatever the appropriate would be, again, why are we even looking at it?
Somebody may misunderstand or misinterpret what the ordinance says and file a complaint, and there's nothing to it because of misunderstanding. Then it's over.
I just wanted to add one more thing. One of the issues that might arise is during the very short time period between the final filing period, there's a 16-day window where if you receive a late contribution, the candidate would be required to file something. But sometimes the filing does not happen in a timely fashion within that 16-day window, so you may receive an allegation of a violation from either the public or another candidate that you have not, we as the staff have not received any documentation on, which is why some of the Board of Supervisors wanted to be sure that we did not alarm the public of a campaign violation during the very short period before the election took place. And that is also why we wanted to add that preliminary review, the pre-hearing procedures, to prevent that kind of explosion of the news.
Is there any purpose at this time, Mr. Smith, to take an overview of how you see our responsibilities in manner of procedures? Would this be a good time, or should we put that on the agenda for the commission?
We can do it now if you like, or put it out over. I leave that to you.
What's the sense of the commission?
What are we talking about?
Yeah.
I'm sorry?
What are we talking about time? How much time would it take you to
How
walk
long
us,
would it take you to?
or run us through it?
Through the hearing procedures, I mean, a cursory, just a quick run through would probably be about 10 minutes. The level of questions would then dictate the total amount of time.
To get overall 10 minutes.
10 minutes is fine.
That'll give us a ballpark. Of what we need.
I think that's terrific. Let's do it.
We try to streamline this process as much
Yes.
as possible.
I looked at it. Yeah.
Okay. Well, in looking at the hearing procedures, I won't read all the definitions, but we have certain defined terms. For example, the administrative hearing, which is I'll give you the quick snapshot of the proceeding as it was envisioned in the draft. Was that a complaint would come in, would be filed with the clerk of the board. Clerk of the board would copy that, send it to the district attorney's office, which is required by the ordinance, and at the same time notify the chair of the commission that a complaint had been received. The chair would then designate one of the commissioners to be the reviewing commissioner to do this probable cause determination that we've just been discussing. And then there would be a 2-week period, basically, during which that process would be conducted. That same 2-week period is also the time in which the district attorney would have to determine whether or not he's going to file criminal charges. Now, that does not mean that at the end of the 2 weeks, if the district attorney does not file charges, he's precluded from doing so. It just means that's his window, where if he wants to act preemptively and do so and ask the commission not to take up the matter while it's being investigated criminally, then that's the time period to do that. If at the end of the 14 days the district attorney has not indicated that they're going to investigate and want the commission not to be engaged in that, and a probable cause determination was made by the reviewing commissioner, then it would be submitted to the commission as a whole. And at that point, the party who's been accused would be notified, and the rest of the proceedings would start. If a determination of no probable cause was found, then the complainant would be notified, and I don't think I dealt with this directly, but presumably they could be given an opportunity to amend if there was something said, well, you've said something here, but what you've said isn't a violation of our ordinance. If you feel there's more, bring it back to us, and if not, go your own way. And then we would get into the next process after a probable cause determination of bringing it before the commission. And the way this is envisioned is that the complainant, when it is a situation where, say, one candidate or one candidates committee or independent committee, if need be, has brought the complaint against another candidate, then that complainant would be responsible for essentially prosecuting the matter before the commission. They can retain counsel if they want to. They do not need to. They can be represented by someone who's not an attorney. The respondent can retain counsel if they want or not. But eventually there would be a hearing, an evidentiary hearing before the commission. If in a different circumstance where there was a violation of recognized or observed by either the staff or by one of the commission members, then the prosecution would be handled by the clerk of the board's office or someone from the CEO's office who was appointed to do that. In the meantime, there's a process for discovery of exchanging documents and witness lists. There's a subpoena power available for depositions if necessary, but generally for documents. That a request for subpoena can be made to the commission. The subpoena would be issued by the commission.
Would subpoenas and requests for documents, discovery, that sort of thing, would that actually come before the commission, or would it be handled by the staff?
Go back and review this. The subpoenas must be issued by the commission. How exactly the commission wants that to be conducted is open. If you want, the request can go to the clerk of the board and then just be brought to the commission or there could be pre-signed forms, and you delegate that authority to the clerk of the board to issue it. I think it can go either way, as long as you have made a formal statement of how you're going to handle that, and if you're delegating that authority, because that authority is vested in the commission. If you're delegating that authority, that is done at a meeting and is in the minutes. And
we should probably that kind of thing should probably be done at the same time we formally adopt our policies and procedures.
Yes, I would agree. We have some timing issues on requests for subpoenas must be submitted no later than 20 calendar days before the administrative hearing, and that's for deposition subpoenas. Subpoenas ducis tecum for documents must be submitted no later than 25 calendar days before the hearing. Again, these are all recommended times. As you finalize the procedures and how you want your commission to operate, you can fine-tune that with the deadlines. If you think they should be shorter or longer, you can feel free to change those. The costs, any costs related to issuance of subpoena will be payable by the person requesting it. As far as administratively, if there's a cost to the county of the actual administrative process of issuing a subpoena, then that cost can be determined and a fee assessed. I don't know if that would be very much or not. But otherwise, once the subpoena is issued, service, things like that would be the responsibility of the party requesting the subpoena. Once a finding has been made that probable cause exists, any party to a matter pending before the commission may request from the other party the names and addresses of witnesses, an opportunity to inspect and make copies of documents, including statements pertaining to the subject matter by any other party or person, other witness statements that are of witnesses that are proposed to be called to testify, any writings that they believe will be brought in evidence before the commission, any investigative reports made by or on behalf of the other party. And I think we envisioned a somewhat more informal discovery process. You didn't have to do specific requests for documents like you would in court, but they need to be in writing, but they can be in a letter format, things like that, as long as they have stated with some specificity the types of things that they're requesting. The procedures allow for...
For a moment, if I may.
Yes.
This is a whole new procedure. Now, the question is, what happens if a complaint comes in closer to Election Day than these particular required days of hearing? Does that mean the hearing, eventually hearing holds over until after the election? Is that the...
It may.
I can't imagine how it could be otherwise. I mean,
Yeah.
the
My
real world.
concern is if X individual is doing stuff that we would eventually find a violation, that fact finding is something the public would deserve prior to the election. That's what concerns me.
You make a good point, but that's a little bit inherent in the process, and that's the problem with last-minute dirty politics with elections. Certainly in the legal press, which I follow, we often see fines imposed on candidates, winners and losers, years after the fact, because after the commission does its work, then there's always resort to the courts and those things. It's not a perfect system, but that's going to happen. It's going to happen, and it happens actually more at the higher levels of elections at the state level because there's so much more at stake.
There are certain due process issues that would arise there with if you tried to hurry a hearing to beat an election date because someone made a complaint close to the election. The defendant or the respondent in the matter who maybe suddenly had to have a hearing in 5 days would claim they didn't have the ability to gather evidence and things like that. So I think once you have procedures in place as far as deadlines for when certain things are going to happen, how long out a hearing must be, that you should pretty much stick to those. You can probably have some wiggle room in there, or on good cause shown, things like that for having a sooner hearing. But in any event, you always have to have in the back of your mind that there'll be a due process issue there, that you have to have sufficient time, reasonable time, for someone to be able to respond to the allegations.
So some of those serious matters, people will go right to court and request injunctive relief.
Okay.
I might ask counsel this: is the work of the commission in any way deemed to be an administrative matter which must be exhausted prior to a candidate going to court?
No,
All right.
no. It's a parallel forum, but there's no exhaustion of remedies requirement.
So if it is late and egregious, there can be injunctive relief.
Yes.
Yeah.
If it's something that's really election changing, you'll probably find the district attorney into it too. I would expect.
I have a question in relation to that. Would be section 1294 of the ordinance under the penalties, where it says under C that no civil action alleging a violation of this ordinance may be filed against a person if the district attorney has filed a criminal action or the commission has filed an administrative action for the same violation. So would that act in any way to limit, at least temporarily, filing of a civil suit?
I have to tell you that that's somewhat of a gray area with that statement, because the commission, as it's set up, doesn't really file any administrative actions. Administrative actions are filed before the commission. So although that's provision is in the ordinance, I don't really know what it means at this point. I don't think that we could preclude someone from bringing a civil suit, especially when there are issues of state law involved, by virtue of this ordinance. To the extent a violation is only a violation of the ordinance, someone might be able to argue that it has to go before the commission, but I don't believe it is that way. I don't believe it is.
One day a
necessary.
real judge will decide that issue.
Yes. Okay, moving on with the procedures. We've provided that when a material witness is unavailable to testify at a hearing, any party may petition the commission for an order that the testimony of that witness be taken by deposition. Again, depositions would be the exception rather than the rule, as we envisioned, when someone was going to be otherwise unavailable. But that possibility is provided for. Again, in section 3.07, we talk about the request for discovery being in writing, and that no particular form is necessary, but they must be served on the other party. Again, as far as service goes, the way we presented this was that all documents submitted to the commission must be served on all other parties, with the exception of the initial complaint. And again, if you want this changed, you may do so. But we set it up that way so that the initial complaint could be filed, but it would be presented to the commission for the probable cause determination. Only after that would it be sent to the accused or the respondent. Part of that was the thinking was to avoid people just filing charges to get the charges splashed across the media, and even if they were totally frivolous. But again, that's something that your commission can look at when you're reviewing these in more detail.
I'm sorry, I have a question on that. If we're initially going to be assigned the job of doing this preliminary review of the complaint, we're only then going to look at the face of the complaint, pretty much like the analogy you gave of the demur. So we would not be expected to get any extrinsic evidence or get a response from the other side. It's just simply look at the face of that allegation?
Yes, the point was not to do any kind of preliminary determination of the merits of the claim, as opposed to just looking at it and saying, is this something that is stating a claim that falls under the jurisdiction of the commission? Or is somebody just off base, or are they is it a harassing type of thing where they're hoping to get something in front of the commission so they can make an opponent look bad, things like that. But no fact finding was envisioned in the draft going out and getting any more information or evidence, things like that.
I'm still not sure what we do in this preliminary. I'm not convinced yet.
Backing up a little bit, upon a finding of probable cause, the clerk of the board, I mentioned before, the clerk of the board would notify the petitioner of the finding that probable cause had been found, and then at that point notify the respondent that a complaint had been filed and probable cause had been found to exist. Also at that time, the clerk would arrange for a pre-hearing conference between the petitioner, respondent, and the reviewing commissioner to discuss some of the initial, sort of like a status conference in court, where let's deal with some of the administrative matters, set some dates, set dates for the hearing, determine whether any kind of subpoena, they thought any subpoenas would be issued, kind of a process to streamline any requests that might come down to the commission for subpoenas, things like that. Discuss what kind of discovery might be sought by the two sides. Not necessarily a forum to discuss the merits of the case, although the ordinance does allow the commission to discuss settlement. So this pre-hearing conference, one option for it would be as a vehicle to discuss settlement at an early stage between the parties, especially if it was it was alleging an actual violation, but maybe more of a minor violation where there was some possibility for corrective action along the lines of a cease and desist order, where, if they agree to stop this practice, will that satisfy you, that kind of thing.
Single commissioners making this determination?
Well, more as at that point, I don't think the commissioner would be making any determinations of orders, but it might be as a sort of a mediator, a facilitator, if the parties are interested in talking settlement. Again, if you have other ideas on how the commission could be involved in the settlement process,
I think we'll have to play that out a little bit. For instance, if a commissioner at that meeting felt that a resolution had been reached, there has to be a technical way to bring closure to that matter, ratification by the commission or not. But at some point, we'll have to address that, and I think we should all keep in mind, we're inventing something here. These are prototypes, and there's going to be a lot of ironing over the next number of election cycles in order to get rid of the wrinkles. There's going to be some stumbles. There always is.
Another option would be for a pre-hearing conference would be to have staff do it, especially as to the administrative details. Now, the thing with the settlement, one of the issues we're trying to get around is, if somebody's trying to settle, they may want to do so with some confidentiality. If it's presented to the full commission, it has to be done in public meeting. If only one or two commissioners are there, it can be. Then you're not violating the Brown Act, and those kind of conversations could occur.
If the parties stipulate the findings and agree to the resolution, then couldn't it be that the complainant removes the complaint, and the issue is resolved? Or once someone makes a complaint, is he stuck with it to follow it through to its logical course?
The problem with what we're talking about here is that if you have a single commissioner making these, and you're calling this an action of the commission, it's not.
Well, a settlement wouldn't necessarily be an action of the commission. It would just be a commission involved in facilitating a settlement. So that's one option to it that you can explore.
The commission will be acting as a mediator in a sense, and not on behalf of the commission, but a mediator between two people who are furious with one another, and maybe they cool down and It does happen.
Maybe a mediator, but you're a mediator on behalf of the commission, whether you like it or not.
There may be, it may be that commissioner may have to be recused in future purpose, if the commission goes further. These are issues we have to address at some point.
Absolutely.
I mean, you're making my point more and more and more. This ought to be done by staff.
Well, in some ways, it could be similar to a settlement conference with a court, where in some situations the judge hearing a case will have a settlement conference.
And obtain a stipulation that if the said settlement doesn't occur, they can go on, and the parties will have waived any complaint that they have about that issue.
Exactly.
We do that all the time in the Court of Appeal.
And the parties know that because this commissioner would be ultimately hearing the case on the merits, that they probably shouldn't disclose more than they want that commissioner to know under those circumstances, but it's a vehicle for settlement. If staff does it, I mean, that's another possibility. Of course, the problem there would be that the staff person isn't on the commission and therefore doesn't bring the weight of the commission's authority to the settlement proceedings, the same issues that are faced by litigants in court. So all options to consider. I proposed one, or jointly we proposed one method, but again, if you have better ideas, please put them in there.
So there'll be a lot of time spent in the first year, I think, exploring these ideas.
Mm-hmm. Okay, the procedures also allow for a proceeding where if they feel that there was a discovery request made, a request for information that was not complied with, that issue could be brought similar to a motion to compel compliance before the commission. Although none of these are intended to get away from normal laws of privilege, if there's attorney-client privilege or other privileges that under the evidence code, those are still valid in this forum. And again, spelled out in here is that nothing in here precludes the parties from engaging in discussions with each other outside of the pre-hearing conference or whatever to discuss settlement or anything, or procedural matters if they want to enter into their own stipulations as to evidence or procedures or just pre-hearing matters, they may do so. We provided that no later than 10 calendar days before the administrative hearing, the parties would deliver to the others a list of witnesses and exhibits or documents that they anticipate offering into evidence at the hearing. It's similar to the discovery, but at that point it's here's what we are going to use, like a witness list and an evidence or document list, exhibit list. There's a provision here for disqualification of commission members for bias, prejudice, interest, or other reason for which a judge may be disqualified for cause in a court of law. Commission members may voluntarily disqualify themselves for any of those reasons, and if so, they would not participate in any further discussions, deliberations, or voting on that matter.
Between the five of us, we're going to know everybody. I mean, it's not that big a county. Yeah.
Well, and then
is there a peremptory challenge? It has to be for cause.
For cause.
Hallelujah.
And parties may, even if there is if a commission member is going to disqualify him or herself, the parties can waive whatever the cause is and allow the commission member to proceed if they put in the record of the hearing.
Would it be considered because I'm not kidding, we're going to know a lot of these people. Mm-hmm. I know every member of the board. Mm-hmm.
Now we own the
board. We all do. Does that preclude us because we know them? I mean,
no.
I wouldn't think so. I hope not, but somebody's going to make that allegation, and we ought to have some idea of what
they can make those allegations. This is a small county. There's not that many judges, and we faced that for many years. And if we follow the same rules that are followed under disqualification of judges, I think we'll be just fine. I don't think if any of us aren't comfortable with it, that's a different story. But for the most part, I don't believe it's going to be a problem. It certainly will be from time to time, but I don't think it's going to be anything that's the people in the Board of Supervisors that make very important decisions know everybody in the county, and it's their business to know everybody in the county because it's their constituents. Yet they
Yeah, but that's a legislative
rule
action.
against us all the time.
Legislative action is, who's the last
That's
person
true.
to talk to them.
Yeah.
I think we were looking at for cause as opposed to, and as I read this, we probably should clarify this a little bit, not proceeding similar to a Code of Civil Procedure 170.6 where someone can just basically file
Well, that's
an
what my
affidavit.
question, it's not a peremptory.
No, it's not a peremptory. They have to file an affidavit with the commission stating with particularity the grounds upon which it is claimed that a member should be disqualified, and which is they have to show the bias, prejudice, interest, et cetera, and that the request to compel a disqualification will be determined by the concurring vote of at least 3 members of the commission. So it will be the commission who then decides whether a fellow member should be disqualified or not, although the commissioner who's the subject of that will be recused from the vote. So, you can assess whether there is a valid reason other than someone just not liking a particular commissioner for a disqualification.
I have a question. If we have in the past, I think for my personal comfort level, I don't feel like I would make any campaign contributions to anyone running for a county office while I sit in the position on the commission. I'm just not comfortable with doing that. But in the past, we may have made contributions to people in prior elections who are running for re-election. And I feel like that's something that I should disclose if, I just don't feel right hearing a matter if it were to come before us and not disclosing it. Doesn't mean that I necessarily feel I can't be fair, but I think that the public should know that. Is there any procedure or that we're supposed to follow with respect to that?
We've not included anything on that specifically. I certainly think it would be a good idea if you thought there was something like that that should be disclosed. So I think it would be similar to a judge, where maybe the judge has some interest in a defendant corporation or something that the judge discloses.
Similarity would be if you have some financial interest, which is a little far afield, but it's not that far afield from what you're saying. And it seems to me that it's a matter of what you're comfortable with. Rather than needing any particular rule for it.
It would be interesting if you had made contributions to previous campaigns of 2 people running for the same office, then, and then they come up with a complaint against one another, and you've contributed to both.
Then you have to disclose how much to each one.
Elections.
That I can't remember, and I hope their records will show it.
It's a wonderful story, which I won't go into about that.
Okay, then as I indicated before, the parties have right to counsel. Or not, as they choose, or they may have someone else represent them. Once we're into the administrative hearing, we have sets forth the basic procedures, but while also allowing the commission at its discretion to modify them in the interest of conducting an efficient and expedient hearing, again with the provision that they don't run afoul of any due process concerns. The administrative hearings shall be open to the public. We've indicated that certain documents should be made a part of the record as a matter of course, including the notice of the hearing, the complaint, if the complainant or petitioner's brief to the commission, the brief submitted by the respondent, and any waivers as to any disqualification issues. And then at that point, it's similar to other hearing procedures. The complainant may make an opening statement. If both petitioner and respondent wish to make opening statements, the petitioner goes first. Respondent may reply or may reserve until the petitioner concludes their case. Petitioner then puts on their case, at the close of which the respondent puts on his or her case. If there's more than one respondent, then the the order of presentation would be decided ahead of time by a mutual agreement, or if they can't agree to it, then by the commission. There's a provision for closing statements or closing arguments, again, with the petitioner proceeding first, the respondent, and then the petitioner having a rebuttal time. No, we've not authorized any motions for dismissal or motion for non-suit based on lack of evidence, things like that. Continuations may be had of the administrative hearing for good cause shown by one of the parties or by any member of the commission. Evidence, this is similar to other administrative proceedings where they don't strictly go with the rules of evidence as you would in court, but it does allow for oral evidence to be taken on oath. The commission will place witnesses under oath, and the oath is set forth here in the procedures. The parties will have the rights to call and examine witnesses, to introduce exhibits, and to cross-examine opposing witnesses, and to impeach any witness, regardless of which party first called that witness. There may be allowed redirect examination and recross-examination, subject to any limitations on that imposed by the commission, so that you don't get this.
Would the rules of evidence, such as they are, be the Administrative Procedure Act, or what rules, or are they whatever we deem admissible?
Yes, we provided that any relevant evidence shall be admitted if it is the sort of evidence on which reasonable persons are accustomed to rely in the conduct of serious affairs, regardless of...
Administrative Procedure Act.
Yeah, and it's similar to what, like, the Civil Service Commission goes by. Hearsay is permissible, is admissible for the purpose of supplementing or explaining other evidence, but if there's an objection raised and it's not sufficient in itself, over objection on hearsay, it shall not be sufficient in itself to support a finding unless it would be admissible over objection in civil actions. So hearsay is, again, allowed just to supplement other evidence unless it meets one of the evidence code exceptions to the hearsay rule. Again, rules of privilege are in full force, and the commission has discretion to exclude evidence if its probative value is substantially outweighed by the probability that its admission will necessitate undue consumption of time. Question? Okay. We've included a prohibition on ex parte communications once the administrator...
One quick question, one phrase. It's just on this chart. These charts are terrific. Who did the charts? May I thank you? They're deliciously clear, except for one phrase that I don't understand at all. Well, here it says, COB, Chairman of the Board, clerks the hearing. I have no idea what clerking a hearing meaning. Clerk of the board. Clerks the hearing. Okay. Now.
That's.
Okay. Now Okay. Now I know what that means. Everything else has been fabulously clear.
Okay. Then again, once the administrative hearing has commenced, the members of the commission shall not participate in any communications with any party, representative, including an attorney, representative of a party or any person who has a direct or indirect interest in the outcome of the proceeding about the subject matter or merits of the case at issue without notice and opportunity of all parties to participate in the communication. And that was worded so that prior to the commencement of the administrative proceeding, commission members could meet to discuss settlement or some of the other administrative housekeeping type issues as far as discovery and deadline scheduling, things like that.
Consider settlement as administrative?
No, I think settlement or administrative matters like we discussed with the pre-hearing.
So any one of us could, if somebody comes to us in the middle of the proceedings, both sides are there, we can sit down and settle it?
I would leave that up to you. I think we envisioned, and maybe it should be a little clearer, with the pre-hearing conference that, as we drafted it, there would be the reviewing commissioner involved at that stage, and that reviewing commissioner could be involved in settlement discussions or other things. I don't think that we would want people just picking a commissioner and coming up and saying, let's talk about my case.
As you can tell, I'm still concerned about that.
That would be a mistake. That would be a mistake.
Yeah, so we can make that, we can clarify that.
If I may, Matt, I think we also put in the procedures that the settlement decisions would be actually brought forward to the commission at their next meeting and ratified by the commission.
Yeah.
There's also, do we have wiggle room in here so that the commission could appoint a settlement officer, a non-commissioner settlement officer to conduct settlement proceedings? Well, I just need to know if we have room in here to do that. If we currently have the discretion to do it, we can do that as we go along. I don't want to make a whole bunch of new rules without, we have to move ahead and change the rules and those kinds of things. But if we do have the discretion to appoint a settlement officer, that would be a terrific thing.
It's not specifically provided for. I can think of no reason why you could not do that.
And we should consider it as giving us the authority and the policies so that we can cover ourselves. But anyway, just an idea.
These things that you're identifying, we can add to the procedures in any manner you want us to. It occurs to me, like we said, we're building something new here, right. And we were just sort of talking about every time you decide one thing should go one way, you think about the conflicts inherent in any one of these sorts of systems.
And there's always the immutable rule of unintended consequences.
Right. So one of the things that Matt mentioned is that it identified that, for instance, our office or the clerk of the board would be would take the position of prosecuting cases that in front of you. And it occurs to me that in some instances, probably those instances that involve board of supervisors elections, that it should not be the clerk of the board, it probably should be the elections division. In those offices, because that's an independent elected official, and therefore there's more removal, certainly from the clerk of the board reports to John Johnston, which is the county exec, who of course is hired by the board of supervisors. So that we might want to think about that in that instance. In the instance where the case deals with another office position, like DA or the county clerk recorder, that should in fact then maybe be handled over on our side of the house rather than by elections, because of the kind of the tie there.
I think we may want to incorporate those matters into the policies and procedures, but we're also covered by the rule of necessity, that we have to do what we can, and yeah. The rule of necessity could cover those things. But I think it's better that we have it in the policies as we flesh out those various offices that may come into conflict, right, and how they support us or don't. Mm-hmm.
As far as settlement officers are concerned, I don't think you need to worry. We can do it if we want it.
Mm-hmm. Yeah, I think, and you might be able to form a list of maybe attorneys or other interested persons with some expertise in the area who could act as settlement officers, much like the courts have with volunteer attorneys to act as mediators. On a similar note, and related to what you were just discussing, I know that in the process of bringing this of drafting the ordinance and bringing it before the Board of Supervisors, Supervisor Bennett at least at one point threw out the suggestion of, as far as a prosecuting entity, that there could be pro bono type where attorneys through the Ventura County Bar Association would be sort of conscripted to serve that role.
There's a lot of people out there who want to be volunteer prosecutors, I can tell you that.
So.
There were.
want to be volunteer mediators.
Yeah.
So I don't think we'll have any trouble.
No, there's no. No, we were talking about volunteer prosecutors.
Yeah, in situations where there's a conflict, I mean, that's always a possibility. I don't know that what, if anything, ever developed with the County Bar Association on that, but that's always those kinds of things are possibilities to bring in an outside person to serve as to prosecute a particular complaint where there's a conflict with the clerk of the board or something like that.
I can just answer briefly. Yes, we did get volunteers. In fact, that's how I ended up in this chair right here. Because I was asked by Supervisor Bennett and Supervisor Long to ask the bar to volunteer, for people to volunteer. I thought I'd set the example and volunteer as well, and never realizing I would end up on the commission itself. But there were volunteers, and you have them. The names were given to the supervisors.
Okay.
So you already have a small pool, and we can always grow that.
Yeah, the people, each supervisor submitted 3 names. We have 10 people we know are interested in the work of this commission, by dint of the fact that they filled out applications. And so they would be people who would very presumably be interested in doing some of this review, or some of these mediation, I should say.
Okay, then just the last 2 sections here. One is on default, where a respondent fails to appear at an administrative hearing. The commission may go ahead and conduct the hearing, and even in the absence of the respondent, or in the alternative, may dispense with the hearing and take under submission the respondent's if there are any written admissions, stipulations entered into between the parties, and other written evidence, and render a decision. If there is a default and the respondent within 7 business days after a decision by the commission that there was a violation, the respondent may serve a notice requesting that the decision be vacated and providing sufficient grounds as to why that decision should be vacated, and at which point the commission, again, in its discretion, may vacate the decision and grant another hearing on a showing of good cause. So they'd have to, again, a good cause for
should a writ of mandate be filed in Superior Court? Is the commission represented by county counsel at that level?
Probably. That issue hasn't been addressed as far as I know, and I don't have the authority to say yes, but that is the normal course. Again, though, if there was a conflict, we might have to bring outside counsel in to represent the commission.
The ordinance does call for county counsel to represent the commission. It just depends on.
It depends if there's a conflict, such as has apparently occurred between the sheriff and the board.
Correct. Well, for example, there are situations where cases are brought against the Civil Service Commission. In some situations, county counsel represents the Civil Service Commission. In other cases, we don't, because we're the ones bringing the writ petition. So it just depends on the situation. I think again, if there was a sitting member of the Board of Supervisors who lost had a decision against them rendered by the commission and then filed a writ petition, we would probably not represent the commission in that matter, just as an example.
Are there any more questions, Mr.
I have a couple other questions about the ordinance itself, but that can be deferred. I don't have any questions. I'm sorry, I don't have any question about the procedures, and thank you for giving us the overview. But I have a couple of questions about the ordinance that I was confused. And I don't know if the chair would like to save those for another evening, because maybe other commissioners have questions about it.
Let me suggest this. As we go through this time after time, we're going to have questions, and I would suggest that any one of us hopefully would feel free, and I guess it's proper, to call you up and answer our questions as we read them. We promise not to do it in the middle of the night, but is that
Yes.
satisfactory? Maybe that's the best way to do it, Tina.
That would be fine with me.
You can contact me if you individually. You can submit them in questions in writing if you want, or by telephone. If you can't reach me, you can submit questions to the clerk of the board and ask that they be passed on to county counsel.
All right. I think we ought to talk about our calendar. I have a sense that we should have a meeting in the next 4 to 6 weeks in order to at least get even the bare bones policies down so we can conduct business. Because there's an election season coming, we have to get started on those. I noticed that or at least on my reading of the material that I have, there does not seem to be a requirement as to how often we meet. Is that correct?
That is correct.
All right.
So it is set at, it's up to your discretion in terms of, the only thing that is set is when there is a complaint.
That's
and
correct.
what calls you to come
I
together.
think that's something that each of us should need to think about, whether or not we should have regular meetings or not. We certainly should have another meeting, at least, or some, so we can iron out those things which we've discovered tonight and which will continue to sprout up, and to get us into a position where we can do the business we've been asked to do.
I would prefer within 4 weeks, because August 31st, I'm going to be away for 3 weeks. So if we go 6
What's
weeks,
the
I'll be out of town.
sense? Let me ask staff. Does staff have a sense of, can it be too soon or can it be too late?
No, I think
What time
I
frame?
think that you probably want to try to do it in the next month or so. What is happening right now is that this ordinance only applies to the supervisors who are up for election at this point in time. Those particular, and that's 3 supervisors. So this is our,
And when is that election? March?
well, March is the primary.
Yeah.
And so what they are starting to file, their required paperwork, and that will be coming through. And this really is our test year, because next year is all of the elected officials plus 2 supervisors who will be up for, those offices will be up for election. So we have our trial on the 3 supervisors who are coming through.
Yeah.
So I would suggest that we try to move forward with at least getting you some operating procedures that you're reasonably comfortable with, so that if something occurs, we have some roadmap for how we're going to handle things.
I see here, what about Thursday, August 28th?
Thursday, August
28th. Does anybody have any comment about that? Okay. Yeah, 7:30. Let's see. And that will be, that also coincides with our deadline on filing our statement of economic interest.
I have a question. If we've already got one on file I have one on file for the court, do I need to do a separate one for this?
That's one of those, I'll get back to you on.
Probably.
Yes, you
The
do.
answer is probably
Yeah.
yes, but all you have to do is change the face sheet.
Right. Yes, you do.
So we can bring the 700s with us then? Okay.
Actually, I think as soon as you can, to please fill them out. And if you have any questions, you can call the clerk of the board's office. We'll help you get through it, but the sooner the better.
Okay.
Are there any matters to be brought before the commission at this time by staff or the public? No? Meeting's adjourned. Damn, and I didn't get to hold anybody in contempt.